So today I am joined by three very close friends and three of the finest lawyers that I have ever worked with that are going to help me talk about this complicated subject today. So I want to do some introductions to begin with. To my far right is Ms. Victoria Gutierrez. She is a 13-year experienced litigation lawyer, works primarily in civil litigation and often in the employment context, both defense and plaintiff side. And Victoria, thanks for joining us today.
Thanks for having me. I'm excited to be here.
Victoria's been a lawyer, for 13 years now?
For 13 years now. It seems like forever.
That's what Mark was saying. And what's your practice area been focused on for that 13 years?
So it's been primarily on plaintiff's work. So representing employees in the context, going against government agencies or private employers because that employee's been discriminated against because of their disability, or they've been sexually harassed, or they've been retaliated against in that context. And then also here at GRT, which I've been excited about, is that I get to provide general counsel to corporations and businesses to sort of try and help protect them from any liabilities that might pop up.
Next is a long-term friend of mine seated to my left, expert in the workers' compensation field, Mr. Don Novi. Don, thanks for joining us this morning. Don is the founder and president of Novi Law Group. He has a very unique background in that he has been a lawyer for many, many years and has operated the Novi Law Group, and they specialize in the area of workers' compensation, which you're going to hear a lot about today. Don has been exposed to the employment union area, space, if you will, pretty much his whole life. His father was a very prominent union member here in California for the California Correctional Peace Officers Association, and Don was immersed in that, and I'm happy to say Don is a very close friend of mine and one of the finest, if not the finest, workers' compensation lawyer that we have all ever had the opportunity to interact with. Don, welcome.
Thanks for having me. This should be exciting. I was raised by a correctional officer and a postal worker, so I'll do my best to not use any profanity, sir.
That's funny. And then finally, to my right is my good long-term friend, Mr. Mark Peacock. Mark is a personal injury litigation specialist. Mark has been in this business for about probably 35 years at this point. 35 years. Not that you look it, brother. What Mark does is Mark is a personal injury plaintiff's litigation lawyer. Mark has a vast trial experience, and Mark has this unique ability to extract the maximum value out of a case for our clients. Again, ladies and gentlemen, what you're going to see today is there's a ton of overlap. I'm going to throw out some hypotheticals, really semi-hypotheticals, because where you're going to see the different practice areas that each of these experts are going to talk about. And we'll go through some hypotheticals today where you'll see how these overlap and how they intersect so significantly.
I'm glad we're all doing this, by the way. And, I would emphasize something that the cooperation with lawyers like we have right here today is extremely important. Because my experience on it, at the bottom line, is it best serves the client, especially when, these environments that erupt, that I represent first responders in. Like typically a typical case would be an automobile accident case or like a rolling code or something like that. That oftentimes requires attention in other areas, employment, workers' compensation, sometimes criminal, things like that. And if you don't have a coordinated effort, if you're not getting along with the other attorneys, some attorneys rush to the end line because they want to get the money or something like that. They don't have the client's best interest in mind. Things can go sideways very, very quickly. So it's really a blessing to be able to work with people here at the table. We're not only just people that work together, but we're friends, and the communication is fantastic.
And I want to point out that I think that is somewhat of a rarity in the legal business, because lawyers, besides being some of the worst business people I've ever met, they are nonsensically competitive sometimes with each other, all to the detriment of the client. And we see this over and over again, where a collaborative approach for the benefit of the client benefits everybody across the board. And that's how we try to tackle every single case that we have. And we have many cases, our respective offices, where we all have a piece of that case. We all touch it.
Yes.
And nobody's competing with each other, and we don't resolve the case or settle a component of the case until we all agree of what's the overall strategy. The overall strategy is not to win your little battle, but the overall strategy is to win the war on behalf of the client, right?
Definitely.
Absolutely.
Okay, so today what I want to do is I have a hypothetical in mind that's not really hypothetical, full disclosure. We had a very, very similar case that I'm going to outline for you, and then I'm going to have Dawn and Victoria and Mark talk about the implications, and we'll circle back to this case throughout the course of the pod. But here's a scenario. You have a police officer who's on duty that responds to a call, but it's a non-emergency call. He responds code 3. Now, code 3 means lights and sirens, going fast, a lot of noise. But in almost all law enforcement agencies, a police officer cannot go code 3 until they get authorization from their supervisor, their sergeant usually, because it's a dangerous scenario. They drive fast, they blow through intersections. This officer decides to go to this non-emergency call, code 3, without supervisory authorization. So this is a liability issue to start with. Traveling at approximately 100 miles an hour, a car on a well-lit, significant roadway, a car blows the intersection through a stop sign right in front of our officer. This vehicle also is driven by a driver who has a measurable amount of alcohol in his system. He's also on probation for a prior DUI arrest, so he's supposed to have no measurable alcohol in his system. So we have that problem there. They collide at a high rate of speed, injuring both parties, the police officer and the negligent driver who drove through the stop sign. Police officer veers off head-on collision to an oncoming car. Oncoming car explodes in a fireball, and that vehicle has 3 passengers. It has a driver who miraculously comes out of it almost unhurt somehow, has a passenger who is killed instantly, and the driver's 2-year-old daughter is in the back seat, not restrained at all. That should have been a second for fatality, but by some miracle, that little girl was not significantly hurt. She was hurt, but not nearly as bad as she could have been, but she wasn't restrained in a car seat. We're going to talk about what that means for the mother who was driving, who also, to complicate matters even further, who also had methamphetamine and marijuana in her system. So that's kind of their foundation. There's a lot to unpack there. There's a lot going on, but this will touch everything we're talking about here. So to begin with this scenario in mind, and we've all worked on similar cases, the first place I want to start with is the injury to our officer. Don, break that down for me.
Well, workers' compensation is a no-fault system. So absent that officer intentionally causing an accident or engaging in some form of horseplay or some illegal activity, that's compensable. So that is going to be work-related. The nature and extent of that officer's injuries probably won't really unfold for quite some time. For starters, because the system is slow, broken, and counterintuitive. Ideally, at these offices... Yeah, I'm just summing it up. So it's Cliff Notes version.
Wait a minute. Let's slow, counterintuitive, and what was the other one?
Broken, I believe. Rewind the tape. Just kidding. So, ultimately, this officer has more likely than not significant injuries based upon the mechanism of injury, and the nature and extent of those injuries likely won't unfold in totality for quite some time because the system is so slow. Diagnostic tests, unless they get rushed in an ambulance to an ER, it's definitely compensable.
So let me throw in some additional facts that occurred in this particular case. Fast forwarding, the officer had significant physical injuries that ultimately required him to retire. He required a surgery, but he also had a significant PTSD claim. And I have Dawn talk about this extensively today. So the PTSD claim that he had arose from a number of different sources. This officer had been an officer for approximately 15 years. He had seen a ridiculous amount of blood, guts, and mayhem in the streets. He'd seen a lot of that over the years that was starting to catch up with him, but he was also feeling extremely guilty about the person that died, the passenger that died on the oncoming vehicle, not to mention the fact that he almost died. An additional layer with this, it wasn't just his physical injuries that led to his need to retire, but he also had a significant, and this might have been even bigger, post-traumatic stress disorder claim. So, Don, you've come across that before, right?
A few times.
How does that complicate matters, or how does it change matters, or does it?
It's multifactorial, Paul. At the end of the day, our first job as attorneys for first responders, or anybody for that matter, is to protect them, right? So my first job is to protect you, the individual that was injured in the line of duty. My next job is to maximize your benefits that you're entitled to by law. So getting back to that first job, right? I can't get to the second job without addressing and assessing the first job, which is protecting those who protect us. That being said, PTSD claims are extremely tricky. Depending upon that individual's past, work-related or non-work related, we have to assess all those elements, if you will, Paul. If they have a past that they don't want being brought to light, you file a PTSD or psych claim, your whole personal life's fair game.
Wait, let me dig down into that a little deeper. Does that mean your whole personal life, not just your life that may have led to the psychological injury?
Well, in theory, right? I mean, a defense attorney can make a very strong argument that, look, I need to really figure out how we got here. I can't just take an MRI on my knee and show an ACL or an MCL tear, right? It's the brain. It's the human makeup. So, yeah, whether you file for bankruptcy, whether you've been divorced, whether you were molested as a kid, whether you saw your aunt hang herself when you were 8 in the garage. I mean, I've come across these are all real scenarios I've come across. And some people don't want to go through that, right? And so in that situation, I would have a very honest conversation with that individual and find out what their level of comfortability is. Hey, if they're okay going through it, let's go through it. If not, let's assess the musculoskeletal physical injuries, because that in and of itself is likely enough to justify an industrial disability retirement, right? And so that goes in the protection vein. Could I make more money pursuing the PTSD claim? Absolutely. But it can get messy.
Let me ask you a question. Can you modify the workers' comp plan? So you say, here's my thinking. You tell a client, hey, let's not file on the PTSD right now.
Absolutely.
For these complicated reasons, let's allow things to unfold. That's an option.
We can
for you.
absolutely amend the claim. Yeah.
Okay.
So
you're not committed from the start.
Correct. So in some instances, we might see how they do, right? Because some people might just say, hey, I'm really shaken up. You know, I've got the survivor's guilt under your scenario or whatever it might be. In that sense, I might just say, hey, go through your private insurance, get some treatment, get some help, see if it works. If it doesn't, then maybe we amend the application, include psych or PTSD, and bring it up from there.
How long do you have to amend that if you did want to amend that so they'd know?
That's a loaded question. It really depends. It's, in theory, the statutes from when you knew or should have known. The rules in workers' comp are fairly loose, right? In the preamble of the labor code, it talks about liberal construction.
Yeah.
Right. And that's not to be misconstrued with our state's political climate. So ultimately, look, if tie goes to the runner, right? If we're using a baseball analogy, that's how it's supposed to be applied. Yeah. Now, a lot of that hinges on what judge you're getting, what defense attorney, what adjuster. It's multifactorial. And so, yeah, absolutely. Sometimes, I will calendar those out, 6, 9, 12 months, and we'll proactively set a follow-up phone appointment or in-person appointment and say, hey, how you doing? Where are you at? Let's check in, because I'm not getting those non-industrial records.
Yeah, exactly.
Right? Because if they're treating outside. And in that vein, I've had a lot of peace officers and firefighters retire, and they go back and teach at academies. And one thing I stress to all of them, emphasize proactive treatment, right?
What do you mean by that?
What I mean by that is go get psychological counseling, whether you're hurting or not.
You mean on your own?
100%. Now, ideally, these departments should lay out a lot more resources and actually proactively push it and encourage it, because I feel that a lot of these individuals could have better coping tools and mechanisms with dealing with these traumatic scenarios. Everybody's different, right? So the human brain is a really powerful tool. And so you might have an individual working at a really, really small town with a low crime rate, safe, right? And they might have an incident that triggers them. Whereas you get someone in Stockton or San Jose or someone with a really high density crime rate, they're a lot more calloused. That doesn't mean they don't have PTSD. It's just they push it back. They push it down. Right? This is how it is. This is how my supervisor taught me. So I'm trying to push proactive treatment to try to mitigate PTSD.
That raises a question that I wanted to ask is I would say over the last several years, there's been a greater emphasis on mental health conditions, mental health treatment. The stigma has been at least somewhat removed from talking about, at least that's my observation.
It's being chipped away.
Yeah. Not that I'm talking about that's totally off.
Hey, you want to release a file here? That's
totally off limits.
That's a much longer segment.
We would need hours. But has that changed your job? I mean, are clients more willing now to bring forward a mental health related claim or not necessarily?
Yeah, I think there's been a significant uptick over the last decade. Honestly, I've seen it increase drastically since COVID, right? The mandated shots, right? A lot of firefighters, a lot of officers, a lot of people in general weren't really in line with the vaccine for whatever reason, right? That's a very personal decision. I'm not going to touch on that. But I know that really put a lot of people in a bad light. They were just making a personal choice, personal decision, good, bad, or indifferent. So I've seen a significant uptick since then because a lot of people were getting disciplined. A lot of people were getting punished for not taking the vaccine. And then finally they just said, screw it. Almost slipped. You're welcome. I'm going to, you know what, I'm done with this. I'm going to file my PTSD claim. I'm stressed out. Now they're thinking, oh, this is in line with me having to take the vaccine. But in reality, once I talk to them and unpack it, right, it's really 5, 10, 15, 20, 25, 30 years of being exposed to these gruesome calls to service.
Yeah.
Right. And it's the straw that broke the camel's back. Same thing that happens in internal affairs investigations.
Yeah.
Right. They finally realize the department doesn't care about me. I got to take care of myself now.
Yeah.
And so they come to me and like, well, optics don't look good from the timing perspective. But let's unpack your calls to service. As uncomfortable as this may be, we need to really direct that medical legal evaluator to the nature of your job and exposure that you've had over your career versus just one myopic IA.
Okay.
Does that make sense?
Yeah, I'm going to talk about that in a second. Okay, we're going to return to this because it's interesting to me that mental health, talking about your mental health and mental health treatment seems to be a more open playing field now. But I do know a lot of the clients we still come across are still old school. When I started my career was suck it up and just move forward.
Yeah.
Soldier on.
Put some Robitussin on it.
Right, rub some dirt on it, and you're good to go. And we're going to talk a lot more about this, about how the comp system plays out. But simultaneously, under our hypothetical, we have a negligent driver who arguably blew a stop sign, had measurable level of alcohol in his system, arguably caused this whole mess. Or did he? Mark, I want you to address that. Like, how would you, as a third-party personal injury lawyer, what options are there for, again, our police officer who was injured severely, not to mention the other dead and injured people in the accident. The driver who blew the stop sign was injured significantly as well. Mm-hmm. That driver, by the way, had insurance, but minimal insurance. But our client is the police officer who clearly has some fault in this, or does he, or does he not? So, Mark, tell me about how you would tackle this.
I'll tell you in a nutshell. When you use the word code, he's rolling code. I would file a lawsuit right away. There's a lot of reasons.
Against who? Who would you?
Against the other driver.
Okay, against the dead.
Because what's going to happen naturally, and by the way, the scenario that you described, that is a very, very typical environment.
Yeah.
Especially rolling code. So what typically happens when rolling codes are going through an intersection, they try and clear the intersection just to refine your hypothetical a little bit. Mm-hmm. And they've got lights and sirens going on. So, you got a full intersection going on. You've got 2, 3, 4, 5 cars there. 2, 3, 4 stop. One guy doesn't stop. Go through the intersection, bingo, bango. And it's very, very typical for the reporting police department who's responding to the accident to lay the fault on the officer for failing to properly clear the intersection. So that, talk about, overlapping in terms of concentrations on what we do. There's an employment issue there. There's a workers' comp issue there. There could be a criminal issue there. And all of a sudden the officers, this is what I'm finding all the time. They suck back like a turtle. They're afraid. I don't want to disrupt my job. I've got a kid. I got my own life. I don't want to lose my job. Now the department's investigating me. So I'll
fill in some other gaps here. And this really occurred. Our officer was in his mid-40s. Our officer had 2 young kids at home and a wife who was a homemaker and volunteered at a preschool or kindergarten or something like that. So he had that concern. After this accident occurred, he's in the hospital naturally, but of course he comes under investigation himself, which I'm going to talk about. He gets put on administrative leave, which led to a major disciplinary action. He was also prosecuted for manslaughter. So we have those different layers. He's very concerned about his career. He's got 2 kids and a wife at home he has to take care of. He is injured, and arguably the guy who drove through the stop sign with alcohol in his system caused this accident.
Yeah.
But did he? I think your argument is he did.
He did. However, even if you split that 50-50, the officer is typically going to get compensated in the civil arena. They have to deal with workers' comp. That's why, like Don and I work together in these types of cases. However, you file right away for a lot of strategic reasons.
And when you say file, what do you mean file? What?
Yeah, it's not to be like just sue everybody. That's not the vibe. What I'm doing is you're reacting to the reality that's presented to the officer. In other words, what does the system do? So the system says, okay, if you want compensation for these injuries, for not just injuries, but loss of earnings, overtime, all these things that affect that officer, that 40-year-old officer. By the way, that's a very real example. Happens all the time. What do? You want to get a compensation for that officer that he rightly is entitled to. It's not like you're taking advantage of the system, nothing like that. Other driver, if I understood your hypothetical, is intoxicated or impaired somehow, boom, right there. That tells me that insurance company is going to get nervous about that. So what I want to do is I want to get that money in for the officer as best I can, as quickly as I can, even before the workers' compensation is necessarily concluded. Because for like what Don's talking about, things in workers' comp sometimes take forever in a day. This officer has certain things available to him, 4850 time, things like that, while they're off. But there is a cliff. There is an abyss of madness, of financial madness that's way over there, but it's going to come. And these guys, when they get closer and closer to, their 4850 time, which basically means...
What do you mean? What's 4850?
They get compensation to 2/3 of their income.
I'll take
what? Yeah, I do.
So it's Labor Code Section 4850. CHP officers have their own 4800.5. So what it is, it's up to a year of your full salary, tax-free, and your accruing service time within a 5-year period from the date of injury. If I may add a wrinkle to this.
Please.
You referenced a small policy from the adverse driver.
Yes.
Okay, let's say it's a 1530 policy, 15,000, 30,000.
Which is exactly what it was.
And you exhaust that quickly. Is there anything else to go after that mark?
Sure.
What is it?
That's a very good question. One of the reasons you file a lawsuit is because you want to explore. Number one, there's two things you're looking at. You want to explore where that offending driver was coming from, where they're going to. Are they on a special errand for some outfit at the local church? I don't want to throw any churches.
The intersection?
Yeah, exactly. There could be a government tort claim there. The other driver didn't see because there's a hedge that wasn't cut. Some issue like that. And if that becomes, there's nothing there, then you look to the officer's own insurance policy. There's a benefit there called the underinsured or uninsured motor coverage.
You mean their personal automobile?
That's correct. Most officers don't know this. They don't know that their own policies apply. And then, by the way, that is also typically a little bit of a journey you have to go through with them, because they say, I didn't cause the accident, or I don't want to make a claim against my own policy. I don't want to get dropped. I don't want my rates to go up. I don't want to draw attention to myself. I just want to go back to work. I want to get better, go back to work. When I said earlier, they become like almost turtles. They get frightened and they get apprehensive. They're trying to protect the world that suddenly is upside down. However, when you find an officer who's got a fantastic policy, and sometimes these guys they're really smart. They have umbrella policies that increase the limits. Then guess what? They're going to be compensated adequately, regardless if the other driver has a 15 policy. By the way, 15 policy, for everybody that doesn't know, that's the minimum in California. Although now, guess what's happening now? You're getting offending drivers with no insurance. That's on an uptick. And the 15 doesn't cover anything anymore. It doesn't cover anything at all anymore. It's ridiculous how expensive things.
Can I ask something on that underinsured, uninsured motorist policy? Is there a recommended level of coverage that you recommend they carry?
Yeah, I'm sure you get this too. That's a very, very good question. I think it's individualized. If they're married, they have kids, if they own property, those are the kinds of things you take in. You find typically younger officers have less coverage because they're trying to save a nickel or a dime on their policies. As they age, they have things to protect. They have property, they have families, they got kids, so they become more aware and they're trying to protect it better. So to answer your question, I always tell them, take a look at your assets. And, do you own a home? And not only just your assets, but your family life. Do you have that kind of thing? And then you get as much as you possibly can. It's got to be six figures.
We have a 40-year-old officer in this scenario.
Okay.
Who, let's say, had 6 years on, right? Even if they're grandfathered under the old pension formula 3 at 50, let's be generous. That's 18%. right? 3 times 6. Well, they're losing out on all of that potential
Yeah.
pension, correct? Are those not
There-
damages that they could collect under an umbrella policy that might cost $300 a year for $1 million?
Okay, absolutely.
Okay,
You're
I'm just-
absolutely correct.
How many Starbucks a week is that?
Exactly.
I mean, for your
me,
protection-
5. Yeah. No, to give
you
a,
see what I'm trying to get the audience here to understand.
I get it.
Increase your insurance coverage for your own family safety.
To answer the question in real life numbers, you want $500,000 of underinsured coverage on your minimum on your basic policy. And if you get an umbrella policy, what you really want to be doing is you want to make sure that the umbrella policy, which expands coverage, you want it to affect your underinsured coverage. So in other words, like Paul was alluding to, you take a $500,000 policy that applies to you, by the way, that protects you. If your umbrella is another $1 million, you want to make sure that $1 million expands to 500. So now you have 1.5 million. That is protecting yourself.
One last question on that vein. Do they need a specific rider or something to confirm that if they are code 3 or they're in the line, course, and scope, that policy does apply?
No, not necessarily. No.
Okay.
If
So
it
there
applies-
would be an exclusion.
No, there's an offset. Insurance companies are not stupid. They figured out that, hey, what they receive in workers' comp, there's an offset. So what they
I'm
receive.
going to ask you both about that.
Yeah. And that's, by the way, that's why you work together with the workers' comp attorney. Otherwise, if you get, somebody off the billboard, guess what? That attorney might be running to the finish line, right, Don? And all they want is they want to get their attorney's fees or something like that. They're not thinking about the client. So what's going to affect the client the best? You want to coordinate. So if you're recovering money, one of the reasons I like to file fast right away is you get the recovery faster. And then you can begin, as that's going on, you deal with the workers' comp environment, you deal with the employment in all those environments at the same time. And that maximizes the recovery for the client.
Okay. Which is the objective.
That's the absolute objective.
But I also want to get Victoria's take on this because here's what also happened.
Okay.
You have civil cases everywhere being filed. You have lawyers filed a wrongful death case on behalf of the deceased passenger. Separate lawyers filed injury case against the driver, mother, and they've also represented the child who was injured in the back seat. Driver who blew the stop sign also filed suit. Now, who did they all file suit against? Well, they all filed suit against the police agency and that particular county, and they named the individual officer. So they recognized that the deep pocket was there. Now, how do you analyze this, Victoria? Because remember, our client in particular, who was worried about whether he's going to end up in bankruptcy over this thing. And to complicate matters further, we have an employer who's saying they may or they may not defend and indemnify that officer because of his misconduct of driving code 3 without authorization at a high rate of speed.
Right.
So tell me how this.
Well, the way I'm looking at it
How do
from
you
the
untangle
beginning
this thing?
is the employer is going to want to not only protect its officer, but also the agency, right? And the number one way you can do that is by preserving evidence, whether that's body-worn cameras from the patrol car, any type of, documentation of what was going on in that scenario. I'm sure I'm sure he called in and said, there's a code 3, and maybe the supervisor didn't reply quick enough. And that's why he went through it. But
Let me add to that.
sure.
He didn't call in.
He didn't call him.
He didn't mention anything about code 3. He was given a non-emergency call. In his mind, he felt that he needed to hustle out to this call. He was familiar with the other officer on the call. He was familiar with the scenario. He thought it was dangerous. For lack of a better word, he didn't bother to make the 10-second radio call to his sergeant to get authorization. He just went.
Okay. Well, I would be really curious to look at is the policy, because maybe there's an exception within that policy, right? Saying that even though you're supposed to do this code 3, what if there's some sort of exception where if you see the scenario a certain way, you can go ahead and blow through it? That's what I would.
You mean the department's policy?
The department's policy
Code 3.
on code 3.
Okay.
Because that would give you a lot of information on what the officer, if he can use his own insight, his own experience. If he was there for 6 years, like Don was mentioning, he may have a little more leeway there.
He did. He had a lot of experience.
Okay. So that's really what I would want to know. And then obviously the other things that pop up is this officer is going to need some sort of more training, right? The public is going to want to know that the police department or the sheriff's department, whoever it is taking this seriously and be transparent with the public so they can feel like they're protected, because that's what police officers do. They protect us. And you're going to want to say, we're investigating it, start an internal investigation into the issue, see if there's any sort of past practices of him not following the rules, the policy, whatever it may be, and then take it from there. I assume that's why he was placed on admin leave. Maybe he had some sort of history, and then the extent of somebody actually dying, I mean, that would warrant some more serious action from the employer.
Yeah, he had actually a stellar record in my hypothetical. No prior discipline, no prior incidents. He was put on admin leave 100% because he was engaged in unauthorized code 3, high rate of speed, involved in a horrific accident, people were killed. So back to, okay, now we have 3 separate civil cases filed against the officer and the police agency. Bear in mind, we also have a workers' compensation claim that Don's handling. We got a third-party case that Mark's handling. And now you have plaintiff's lawyers who want money, and they're now noticing up depositions. I mean, now you're representing the officer. And first, let me ask you this. Under that scenario where the officer has been placed on admin leave, I did add before, is being prosecuted as well. So that's a whole separate wrinkle I'll talk about.
For manslaughter, right?
Yeah, for manslaughter.
Got it.
Is likely to be disciplined, is severely hurt. Is there a conflict of interest between the county, in that case, and the officer? In other words, is that officer entitled to separate representation?
So, yeah. So the labor code says that the agency should be responsible for representing them. But if there is a conflict of interest, they would have to hire somebody to represent the officer separately. So I've had a specific case where we're suing a county and they actually engage in separate counsel for the police officer because they don't want to start the process and then later find out that there's a conflict of interest. So if I was giving an employer advice, I'd say from the beginning, have separate attorneys so you don't come across any sort of issues in the near future.
Who pays for that lawyer?
It would have to be the employer.
The employer.
Yes.
You know what? On that note, what I try and do, that's when I insert myself just a tad and convince everybody to drop the officer as a defendant.
Yes, that's actually a really great point.
Yeah.
A lot of the time, so when I'm working on the plaintiff side, at times I'll add the individual defendant and then I'll use that as sort of negotiation to, either get them to pay more or whatever it may be, but to always try and drop the individual.
Yeah.
So it's a good tactic too.
Hey, let me understand this. From the civil plaintiff's point of view, say the lawyers that are representing the deceased passenger, why would you ever agree to drop the individual officer?
The reality is they don't really have personal exposure. Everything that they're going to be responsible to pay out of pocket. It's going to be on the county, the city, whoever it might be. So the idea is to allow them to get out of the case personally because there's no exposure to them personally. And there's concessions to that. It's a negotiating moment. So everything from, hey, we'll make the officer available for deposition. We'll do X, Y, and Z. Hey, take his depo or her depo first. Say there's no reason to keep him in. You're not going to get any more. That's not going to be an issue at trial, things like that. Plus, I use that typically to get the officer out, to lower the temperature for the officer, because the officers, in my experience, they're scared. They're afraid that you can tell them sometimes all day, night that you're not gonna lose assets. Your life's not gonna fall apart. They're still afraid. They don't trust the system in general. So, I use it as a moment to not only negotiate getting him out of the case, but I use it typically in the civil environment, which, by the way, what typically happens if there's a criminal case going, there's a motion to stay, everything is stayed. Correct. That does not prevent me, though, from talking with the insurance company. A lot of times, if there's an attractive amount of insurance there, that it's maybe a little bit more than typical. A lot of times, insurance companies, just to get out of the environment, will pay it and say, "Okay, you deal with comp, you deal with working, a deal out with the city or the county or whoever," and in that way, you remove the officer and you kind of reposition everything. Okay. And all the claims, though, by the way, are maintained. Everybody's claims against the city, county, whoever it was, and the officer are still maintained. They don't lose anything. They're still going to get their money, if you will. The parties or the attorneys or whatever.
Okay, but back to Victoria. The plaintiff's lawyers are seeking millions of dollars for these injuries and the death involved in this accident. And if you're advising the employer, there's people in the employer that are asking you, say, wait a minute, why should we cover this officer? And why should we defend him? Because he broke our policy and was driving at a ridiculous rate of speed. And had he followed the policy of the department, this accident would have never occurred. Easy for everyone to say in retrospect, would have never occurred. And therefore, he was on a personal adventure outside the course and scope of his job, arguably. He is personally exposed. That has to come up, right?
Yeah, I mean, it would, but I guess my first response would be that it's statutory. The labor code requires for you to cover your employees, regardless of whether they're on their own venture. If he's in a police car, patrol car,
Yeah, he will.
in his uniform, then he's most likely on duty, right? And so I would say I understand your sentiments, but this is what we have to deal with now, and that's why I would suggest for the employer to get two separate attorneys from the beginning.
Yeah.
But also speaking to Mark's comment about the officers feeling fear, that also comes in because they're also injured, right? And once they're injured, the employer is going to have to accommodate them. They should begin that process of interactive process, it's actually called. Those are.
If I can add a quick
Yeah.
break
Yeah,
or
please.
question.
Yeah.
We talked about our officers' personal insurance policy. Where does that insurance defense come into play in this?
Great question.
That is a great question, Mark. I think you should take that.
It would typically the civil matter, if I understand it.
Yeah. Yeah.
You know, his personal policy may apply in that regard, but he's always going to tender to his employer always to cover them because they're in the course and scope. That's what happens. Some plaintiffs' attorneys who are representing the injured driver on the other side, you know, they want to include everybody and their mother into it to try, you know, look for money sources and things like that. But at the end of the day, it's not going to be the officer's personal policy that applies. So the indemnity part of his policy, the indemnity, by the way, is the part that pays, you know, recoveries or verdicts and things like that. But their duty to defend, that they typically what you see is they'll say, okay, we're going to defend the moment under what's called a reservation of rights. So they go, we'll do it, but we don't think that we need to do it. When I say we, I mean the officer's insurance policy. And then what that attorney does for the officer is they turn to the employer. They say, you cover it. And if you don't, we're going to file something against you, retaliation or something like that. Lack of coverage, but bad faith.
So they would be more of what we call a passive litigant. They're sitting there and making sure
Right.
the
Exactly.
employer's doing what they're legally obligated to do.
Right.
So their personal policy is more of a sword, if anything, for their own benefit
Yes.
in the event.
Exactly right. That's exactly right.
Now, one of the key takeaways so far from this morning, this is fantastic, ladies and gentlemen. This is great. I really appreciate this.
You're welcome.
Yeah. But one of the key takeaways that cannot be overemphasized enough is max out your underinsured, uninsured motorist coverage on your auto and get an umbrella policy that's appropriate. This stuff is cheap by comparison, and if you need it, it'll save your bacon.
I've been giving that speech for 25 years. And just to emphasize it, it is cheap. If you go out, you price it, it's cheap. It's not like you're spending $1,000 a month for it. It's cheap.
It's
Price it out.
It's 130 pack of Modelo's a month.
And Don would know. What do they cost?
Allegedly.
Allegedly.
Okay, so that's our takeaway, ladies and gentlemen.
Modelo line.
Please do us a favor, so I don't have to listen to Mark for the next 25 years talk about this. Our hypothetical here, we have some other additional complications. As I mentioned before, the local district attorney filed manslaughter charges against the officer related to the deceased passenger in the vehicle where the head-on collision occurred, arguing that the officer's conduct by driving at such a high rate of speed without Code 3 authorization was grossly negligent or reckless. Therefore, he was liable. Criminally liable means you go to prison and sit your, excuse my language, in jail for
It's the first time, Paul.
Yeah, it's first time.
Did you
It's
break
American.
the seal?
Yeah, I gotta pay.
Paul just
Is that
stepped
a
out.
green light?
Producer Jeff is waving at me, so I got to pay a fine for that. But I mean, it was a real threat. Talk about, you know, stressing you out. Not only do you have all these other things that Dawn and Mark and Victoria have been talking about, but now he's got the real potential of going to prison on top of everything else. And his department put him on administrative leave while they conducted an investigation, and in relatively short order, about 3 months, under our hypothetical, they terminated the officer for gross misconduct. No prior discipline, by the way. They terminate the officer for gross misconduct for driving at a high rate of speed without Code 3 authorization and causing this accident. So I could speak to those two areas, the disciplinary side of it and the criminal side of it, and we could spend hours diving into that. But as you can see, there's an overlap in all of these areas. What the criminal case could do and did would be stay the civil proceedings of the plaintiff's lawyers, so Victoria's cases are stayed. Because what those plaintiff's lawyers wanted to do was, as soon as possible, take the deposition of the officer. impossible to do because that's a voluntary statement. The Fifth Amendment of the U.S. Constitution prohibits or gives our client the right to remain silent and not make a statement. So how does that interplay? Well, how it interplays is what most courts do is they'll stay the civil case, and I mean the civil case against the department, the county, and the officer while the criminal case is pending. It doesn't stay the third-party case Mark is working on. It doesn't stay necessarily the workers' compensation claim, although I want to ask Mark and Don about this as well. Criminal case could take a year and a half to resolve, and if it goes to trial, there's the question of, do you have the client testify? Because his testimony will be used in all these other cases we're talking about here. So there's a whole strategy analysis that has to be done on that. Then there's the disciplinary case. Now, the disciplinary case, the officer's been terminated, and he has the right to an administrative appeal, usually in arbitration. That happens in relatively short order. But that's tricky because to successfully fight your disciplinary case, the officer needs to testify in his disciplinary hearing. And again, that testimony gets used in Don's workers' compensation matter, in Mark's third-party personal injury matter, in Victoria's 3 civil cases.
And then there's impeachment there too, which I mean is another layer of problems, right?
Yes, 100%. So if the officer testifies in any of those proceedings, which is going to be viewed as a voluntary statement, if that testimony is defective or inaccurate in any way, it's going to get used across the board.
And if I might emphasize, I mean, what you're talking about, it could potentially be jail time. What we talk about is money. And so the objectives are a little bit different. So I typically don't want those types of hearings happening until I get the civil case resolved somehow. And I don't want the officer to necessarily testify. I already know what the officer is going to say. You know, that's important.
Correct.
So what I try and do is you change the paradigm of the insurance company that I deal with on the other side. Hey, don't worry about that. What's more important is to me, it is, and it's certainly to all the clients I represent, I could safely say that, is they don't want to go to prison. They don't want to lose their job.
No.
You could always put the money off. So that part of the cases are, to me, more important. But you have to coordinate. If I'm not calling you, asking you, hey, what's going on? I'm not serving my client very well. All I'm thinking about some money environment that's not necessarily going to serve him very well.
So I think in large part collaboratively, we employ a 30,000-foot approach, right? Most attorneys, I think, when they're looking at these cases in their own little compartment, instead of working collaboratively, will look at these cases from 100, 200 feet and just look at their little bubble, right? When we look at these cases and we approach them, we're trying to look at all the possible scenarios. What's our first job? To protect you, right? And so at the end of the day, without us collaborating, without us discussing what's in your best interest with your input, we can't get there. So without these collaborative approaches, any first responder could have their liberty and freedoms in jeopardy just by not having those dialogues open and fluid.
That's a good point.
That's very well.
I've had cases where we did not represent the employee in the criminal case, but there were other active cases like a workers' compensation case and a civil case. We were involved in the civil side. And they had some local, not overly sophisticated criminal defense lawyer who pled them out early on to a felony, promised later to be reduced to a misdemeanor. But now that employee of ours, who is our client in these other cases, is a convicted felon and had to make a statement of fact in his plea deal as to what misconduct he's admitting to have occurred. Disaster.
That's no bueno.
Yeah, exactly.
No bueno.
That's your official legal.
Say it better, guys. No bueno.
I know.
That could potentially destroy a civil environment, just so you know. If you haven't plead out and all of a sudden, insurance companies.
That's why I'm somewhat animated right now, because I know.
So, and I've had plenty of cases, unfortunately, where there are some criminal components, and I'll have a client call me paranoid. Again, I'm representing him in the workers' compensation arena, and my attorney's saying this, that, and the other. It's like, give my cell phone. Let's talk, right? And so I will sit there and have candid discussions, and I can't tell you how many times, Paul, that I've had the criminal defense attorney say, "Oh, I didn't even think about that," right? And so, for example, they tried to, hypothetically, broker something to where the medical legal reports could be viewed, or no, I take it back. The investigation reports would be sent to the QMEs in the workers' comp case. I said, absolutely not.
Well,
I go, absolutely not.
first of all, what's QME stand
That's
for?
fair. Qualified medical evaluator.
Okay.
So in workers' compensation, you typically have a medical legal evaluation by a QME, which is a qualified medical evaluator,
Okay.
or an AME, which is an agreed medical evaluator. They are charged with reviewing your medical records, interviewing, examining you, and ultimately issue the comprehensive report in most cases for which compensability or it's accepted as work-related, disability ratings, payouts, medical treatment, et cetera. So getting back to this hypothetical, I talked to this criminal defense attorney, allegedly, and or hypothetically. That's why they want to run it by me. I was like, no. DA ended up dropping the charges completely. It was a railroad job, right? And so ultimately, had that path gone down, it would have been a rabbit hole. I don't think the DA would have ultimately, because the QMEs could have muddied the waters, because they have one job, right? Not to really engage in the criminal side,
Yeah.
administrative side.
Yeah, exactly.
It's here. And so I didn't want to muddy the waters in the workers' comp arena, more so because I didn't want to add more fuel to the criminal side, right? Our biggest job, our first job is to protect you, right? And so when there's a criminal component, all radars go up. So
Okay.
collaborating is huge.
Let me complicate this matter even further, believe it or not. In addition to all the other things we've talked about, there's also a licensing component. In California, virtually every job now, every profession is a licensed job. So if you're a police officer, you have licensing through post. If you're a paramedic or an EMT, you have licensing through the local EMS agency and the statewide EMS agency. All of us as lawyers, we are all licensed professionals through the California State Bar. So to complicate matters even further, that local licensing agency is likely to take disciplinary action against this employee, regardless of anything else, regardless of the pending disciplinary case, the pending civil cases, the pending criminal case, the third-party claim, and the workers' compensation claim. They are likely to take independent action against that particular employee where they could revoke their license. So all things being equal, if their license is revoked, they can't work. They can't operate in. So that has to be on the radars. Well, we do a lot of licensing defense here, and that has to be coordinated into the entire analysis. And it really comes down to, I think Mark said it, it comes down to a matter of priority. What's the most important? In the case of my clients, and I've done a ton of criminal defense work in state and federal court for public safety employees and other employees, usually in order of priority, their first concern is they want to stay out of prison and jail, because that is a no fun experience for civilians like us, but also it's even worse for public safety. But then number two, closely followed, ties in with Mark and Don, is they're worried, like, how am I going to feed the kids? How do I pay the bills? I live in California. It's expensive. We're kind of month to month like most people. What am I going to do? So that is a major pain point that, frequently their employment comes third or is tertiary, but that's tied in with the money as well. And then if they're held personally liable on the civil cases, they're in bankruptcy court in all likelihood.
Right. Definitely.
So, those are the complications. One other thing I wanted to touch on in the analysis with all the lawyers and your different claims here is one thing we look for from the start is, did that officer in our hypothetical or the employee or the client, have they given any statements out there just following the incident or after the incident? Have they text messaged? Have they emailed? Have they posted on social media? Have they done anything that's contrary to their interests? Did they admit in a text message the misconduct? You need to drill down on this ASAP. And one of the biggest takeaways, and many of you have heard me rant and talk about this before, is do not give statements. If you're involved in an incident, do not give any statement until you talk to all your lawyers very carefully about whether you should give a statement. And probably the best advice I give you is throw your cell phone in the river. Do not text, do not email, do not social media from your cell phone about your particular incident. It will come back and bite you 100% of the time.
That's very true in employment cases as well. I mean, if you file a lawsuit, they are entitled in discovery process to get your text messages between employees. So if you're, for instance, claiming you were sexually harassed, but then you're sending text messages that are later discovered that dispute that, then that becomes a problem. So you really need to be careful with your cell phone.
And can they get access to?
Yeah, at times. So there'll be a motion to make sure that they're not like extensive, so you won't be able to get everything, but you'll be able to. There's motion to compel.
And I'm sure you've experienced this. Even if they've deleted everything, you still can get the record. So if an officer has an Instagram account and they're doing whatever they do, they delete it after this environment, they can still go back and get the information. There's case law on that now. And when I get discovery, and I don't know if you get this as well, when I get discovery, it's like, give me all, Facebook DMs or give me all postings.
I do. And I say, no, I'll give you 5 years or 2 years. Always try and limit it.
I don't know if you experience this. Now they give instructions in the interrogatories or the request to produce how to go get the archived counts. So they go, okay, even if they've been deleted, this is how you go into Instagram or whatever it is, WhatsApp or whatever these things are, and how to get that information. And the Facebooks of the world, they keep that information. It's still there. So yeah, the social media stuff it can be disastrous.
How this comes down frequently is, and this can be a disaster for everyone, is if there's a criminal case, especially a federal prosecution, the FBI and the U.S. attorney, who have unlimited resources when they decide they want to do a case, and they often do them for highly political reasons. But when they do a case, they will get a search warrant for your phone and all your phone records and your password. And if you have your phone, still you haven't followed my advice and crushed it, burned it, and thrown all the pieces in 6 different rivers, they will get access to that. And then they have access to, and I'm not kidding you, they have access to your entire life, your emails, everything, all your photographs. And we recently had a case earlier this year that involved a series of search warrants on cell phones where they recovered from our client 1 million, more than 1 million text messages that he was involved in, either individually or in groups. The FBI got this over the course of about a 6-year period of time. Wow. Very prolific texters. And get this, we made all kinds of suppression motions. We lost. The judge ruled that I, for example, do not have an expectation of privacy to the text messages I send Don, Victoria, or Mark. So
wait a minute.
Exactly.
Part's deleting right now.
So if I text Victoria,
Where's the river?
Or we're involved in a group text. So let's say the 4 of us are involved in a group texting situation where we're texting all about our cases. Maybe pictures are going back and forth. Maybe it's not personal. Maybe it's not entirely appropriate. And Dawn, Mark, and I all get rid of our phones, but Victoria doesn't.
Oh.
Now they have access. Thanks, Victoria. They have access to all of our texts. And this judge ruled, and there's law supporting this, that Dawn, Mark, and I do not have an expectation of privacy in that group text as it relates to Victoria's cell phone.
So yeah, social media is not your friend.
No.
And what I tell clients all the time in workers' compensation is, prospective clients, if you're talking to the adjuster, follow it up in an email. Because if it's not in writing, it didn't happen.
Yeah.
It's the inverse here. Don't put it in writing.
You know what? Actually, I want to add to that. So I've had a few employment law cases where the plaintiff or the defense will post things on other platforms too, like Reddit, under a different name, and you're still able to figure out who that person is. I had a sexual harassment case, and the defendant was paying for a lot of inappropriate things, but he would do code words or pictures in his Venmo. So then we were able to get his Venmo, and it was slightly entertaining looking at all the different things and what they meant. And I'd asked him about it in depo, and he tried to deny it. And it was just a really insightful deposition. So, I mean, just be careful. It's not only, it goes back to
emoji education.
Everything. Yeah, exactly. Emoji education.
I like to, what I tend to do with clients is I say, if you need to say anything, do anything, call me up. And if you want to, complain, call me up, and I'll campfire with you. So anything you're saying with me is protected. It's not going anywhere. There's absolutely no reason I would be leaking in.
You protected under what? The attorney-client privilege?
Exactly, attorney-client privilege. And that's, so I like to do that as a sort of a pressure valve release, if you will. And because my clients, they're involved in these kinds of environments that we're talking about. They are under an enormous amount of pressure. They're scared, validly so. So that's kind of some way that I deal with that. Like, you want to yell, scream, call me up.
That's nice, Mark.
Yeah.
Talk at me.
What a good guy.
Yell to me, not at.
Exactly.
Deal with that a lot.
I want to circle back to at this minute. Bearing in mind we have all these other complications going on, I want to circle back to the interplay between the third-party personal injury claim and the workers' compensation claim. So Mark has filed his suit. Say we're 6 to 12 months out of the accident. The officer's treating, but is not permanent stationary. What does that mean, Don?
The definition of permanent and stationary, Paul, is you're not going to get significantly better or significantly worse over the next 12 months with or without treatment. In layman's terms, it means you've medically plateaued. There's nothing crazy in the treatment that's being recommended. There's no surgeries pending. There's no crazy injections that can give you significant relief. You've plateaued.
That was a beautiful definition.
That
really
best
was.
definition I've heard.
I know.
Yeah.
Yeah.
You worked on that one. Oh.
I've said it a few times.
Yeah. Don said that a few million times. So what I want to talk about now is now Mark's at a point where he can settle this claim, or he's getting close to settling this claim with the either defendant's insurance company. And remember, this is the guy who ran the stop sign, who arguably caused at least part of the accident, and our officer's underinsured motorist coverage. Mark's at a point to settle that, but there's an effect on the workers' compensation claim, correct?
There is.
So how do you tell me how you two gentlemen handle it at this point for the benefit of the client?
Okay, so one of the reasons, what'd you say?
I said it's layered.
It is very much.
It's not a simple question.
And no, it's not. And you do have to coordinate. So what I like to do I call it the underlying case, which means the case against the other driver. I want to get the other drivers, their entire environment, all the insurance money that's available, even if the officer is continuing to treat. So in Don's world, it's not matured yet. It's not PNS. It's not permanent it's not permanent stationary. So that's what I'm looking for, not in terms of the underlying case, but in terms of the UIM, the officer's own insurance. If the officer is still treating in workers' comp and they're not permanent and stationary yet, then the UIM, one of the components that effectuates that, one of the, in other words, how does the benefit of your insurance become available to you? One of the components is the officer has to be PNS. The officer has to be permanent and stationary. And then the insurance company will go, okay, now we'll play ball. So you could have lots of money over here in your UIM, but you cannot access it until the officer is PNS'd. Okay.
Okay, let's move this hypothetical up. So the officer is permanent stationary.
Okay.
Now, you're talking to people on your side. Don, now what are you doing on the workers' compensation side at this point?
If the injured officer, for example, or firefighter is permanent and stationary, and they are still employed, let's say they went back to work full duty, right? That's where it gets a little tricky for Mark on the UIM component, because there is an offset. So let's say hypothetically, there's a $100,000 underinsured motorist policy, and there's a $15,000 third-party policy. So there's $85,000 left under the UM.
That's correct.
Okay, so 100 minus 15 is 85. I'm mathing. So now the workers' comp pays out $60,000, right? So now how much is left on the UM? 25,
yeah.
Right? So the tricky part, and the reason
There's
being...
an offset?
There's an
correct.
offset.
So UM gets credit for what workers' comp is paid out. So not only they're getting the 100 minus the 15, so it's 85, then 85 minus the 60, right? So there's 25 left. So under that scenario, the tricky part is the UM carrier might say, well, he's got open medical.
Yeah, exactly.
Make me,
Yep.
right? Because we have an ongoing ticker here where they're going to be paying out medical treatment, so our offset keeps dropping, right? So that's where it gets tricky in your world, because there's an open-ended check, if you will, on the open medical award, which could stall out the UM.
And that's on your side. That's on the workers' compensation.
Correct. So where it gets, if it's very conservative medical, like periodic treatment, occasional physical therapy, injections, then maybe, Mark can get it done. But compromise and release agreement, they're no longer working there. We do a lump sum settlement. Now Mark's playing ball. Now Mark has workers' comp is settled and done. Let's say they paid out 60 in total. He knows he's got 25. He's going to get it. Does that make a little sense?
Yeah. One thing that might help our viewers and help me understand it better is when a workers' compensation case winds down, how does the client get paid, or how there's two different ways, right?
Yeah. So ultimately in workers' compensation, there's stipulations with requests for award. We call them STIPs. So STIPs are, in operation, you're going to have a future medical component attached to your work-related injuries. and whatever disability rating you have attached from that QME or AME, right? When they evaluate you, they're going to assign a permanent disability rating that ends up coming from that evaluation. That disability rating equals a specific dollar amount by law. 10% equals X, 20% equals Y, so on and so forth. So let's say they have a $20,000 permanent disability award. That's paid out of $580 every 2 weeks until that award's exhausted. And then they have open medical. Okay, so that's tax-free money.
And open medical, is that for life?
It is.
Is that related to all medical conditions or just related to the accident?
Just in connection with the industrial injuries. So the accident, right? So let's say this guy has a herniated L4, L5, L5S1, broken clavicle. So whatever body parts are associated with that industrial accident, that's what the future medical attaches to. So that's one type of settlement.
Got it.
Okay. The other type of settlement is called a compromise and release agreement. We call it a C&R, Charlie and Robert. And that is a lump sum settlement. So let's say that $20,000 permanent disability value I talked about. Now we got to find out what the doctors are recommending for future medical treatment. Is there a possibility that they need a total knee replacement in the future, right? Do they need, injections 3 times a year, neurosurgical consults? I don't know, right? And so we come up with a calculation on a future medical value, right? Now, that's where it gets a little tricky because everybody says, well, surgery costs 60 grand for this total knee replacement. Well, that might cost 32 grand for work comp, right? Because the work comp fee schedule is in essence attached to the Medi-Cal fee schedule. It's really, really low, right? And so you're not going to get the true value of that future medical on a lump sum settlement. Now, that being said, you're free and clear, and that money's now yours and it's vested.
So you're out.
Yeah. So let me take that one up one notch. Let's say the permanent disability award was $100,000. So that's paid out of $580 every 2 weeks. Let's say you die and only $40,000 has been paid out. That money does not vest.
Doesn't go to your
Does not
estate?
go to the estate. No, it goes to the state of California, if anything. Right. And so a lot of people will opt to do the compromise and release agreement for 2 main reasons. One, that's realized money. It's a bird in the hand. 2, now they can control their own medical treatment. Right. And so technically on the safe side, I tell a client, let's say 60 grand was the value of future medical. If you want to play it safe, put that 60 grand in a medical trust account on your own. Pay for whatever you want that's related to your injuries if you want to play it safe. Most people have an intervening event, i.e. I was lifting a box off a shelf at a garage and I felt a twinge in my shoulder. Well, crap, that was my workers' comp case. Well, no, now you have a new intervening event. Your private insurance cannot discriminate against you for a pre-existing injury or illness.
Okay, so you're going to be covered by your existing insurance probably.
Hypothetically, depends on how you report it, right? So if you report it like I was doing this, some people are going, well, I had this old workers' comp injury and, my shoulders flared up. It's like, sorry, you're going to have to go through comp. No, it's settled. Well, no, it is factual that every single day, right? If you have a pre-existing injury, you're doing something at home, at work, at a grocery store that will aggravate or bother a pre-existing injury. Yep. I'm having a hip replacement in February, right? So I can just be out there walking and all of a sudden my hip starts flaring up, right? Well, I was walking over uneven ground and I stepped in a pothole dock, right? So as long as you're reporting the new intervening events, shouldn't have any issues.
Okay, but that's huge that the claimant needs some expert advice on how to report the thing.
Yeah, I would say this. Don, you did.
My clients are well educated.
Yeah, I was going to say you do a fantastic job of describing that.
That's the exception, not the rule.
And that's you can see, I would assume if you're a lay person or an officer or something, how complicated it gets. So you need to have competent attorneys handling that environment. When I'm interacting with that environment, I want to make sure that he knows what he's doing. Because if you get no offense to comp attorneys out there or just, billboard people or whatever, if they don't know what they're doing, they just want to get things done and get out. You don't know how it affects the officer. So if I'm settling a case, I'm concerned about that. And I want to know that, and we want to coordinate because that's going to mean compensation to the client. So sometimes that environment, I'll give you an example. Sometimes that environment, there's not enough insurance to go around. So he used $100,000 as an example. Let's say I have $100,000 over here. Well, it doesn't really, in certain environments, as an attorney, I and the employer are going to be the only ones getting compensated, theoretically, from that recovery. But you don't do that. And if you want to take care of that officer, you cut a deal. You cut a deal with the employer in terms of their lien, cut a deal so the money gets moved around and it's not tagged. And so you don't want it to be applied as a credit against like the medical.
Okay.
But let me, you said something I want to drill down a little deeper. You said the employer's lien. What lien? Victoria, what lien are we talking about here?
Through workers' comp. That's what I meant.
The workers' comp lien is what he's talking about.
Okay, so it sounds like we have a situation here where there's various pots of money out there that could take care of our injured officer, but we have the various insurance companies and employers involved that are entitled to offsets and reimbursements
Yes.
all over the place.
And if this, I would suggest, I would hope you'd support me on this one. This is why you coordinate. Because if you don't coordinate, if you get some guy off a billboard doing what I do,
Stubby, he's mentioned billboards a few times. I suspect Mark has had a less than stellar experience with someone on a billboard. Go ahead.
shocking. But those types of attorneys, what they'll want to do is they'll want to come in, get their fee, and get out, and they don't care, or they'll look at the client and go, "Hey, I'm sorry, the city, the county, whoever your employers, they get it all back because of comp."
What does that
And
do?
they go, and then the officer goes, "Well, then why did we even do this?"
Can I break this down in
Yeah,
those terms?
that's what I want to do at this point.
So
And then can you tell us if the money that you get from the CNR is taxed or not? I think, did you say no?
tax,
Not taxed. Okay.
right? So it's not considered income.
Okay, that's
So hypothetical, officer involved, motor vehicle accident, person runs a stop sign, right? So we have a companion case, is what we refer to it as.
Exactly.
So we have a workers' compensation component and we have a personal injury component. When you're treating under workers' compensation, they are paying medical bills on your behalf, and they're likely paying you 4850 benefits, which is your full salary, tax-free. So the employer is racking up a bill, right? They're paying tens of thousands of dollars on your behalf through workers' compensation. It's a no-fault policy. They are responsible for that. Now, you have a third party that caused the injury to that officer. Your employer shouldn't bear the burden, and this is the public policy rationale behind it, of footing the bill, and you get compensated on top of that. You're double dipping, right? And so the way this works is if you're going to get a recovery in a third party case, your employer, the insurance company, has an absolute lien and credit right. Now, let's break it up into two parts. A lien, right, is something retroactive, right? So I've paid out $50,000 on behalf of Officer Smith. I want 50 grand back out of this personal injury case because I'm paying for it. Where you get the money and I'm paying for it, right? That's one scenario. Now we have the credit, right? So if the client gets $100,000 in their pocket from the personal injury case, now the employer has a $100,000 credit prospective future
On all benefits.
on all species of benefits. Now we get really creative, and this is where it really comes into play, having attorneys that work together, because we negotiate things in a lot of situations, a lot of times against our economic interests, because that's not what the controlling factor is to protect you. So
I guess
Wait a
maximizing
minute.
our fees is not
So-
the...
Yeah, but well, hold on. I want to say kudos for highlighting that, because the truth of the matter is we are giving back.
100%.
And you were helping these officers out.
100%.
Yes. And that
So we can leave them holding a bill with no medical coverage or anything
Yeah.
illegally,
yeah.
right? But
Now,
that's
by the
why
way,
we do what we do.
those billboard guys, they do stuff like that. That's my cynicism. We'll leave that alone.
Okay, I don't have a problem with all billboard attorneys. You know who I'm talking about.
Neither do I.
He
does.
Neither do
So-
I.
Me either.
Neither do I.
In any event, so the lien and credit gets a little tricky. Long story short, anytime you have a companion case, I think it's important that you speak to your workers' compensation and personal injury attorney together, right? So you want to confirm they know what the hell they're talking about with each other. Because if one claims they know and the other one claims they know, but they're not talking the same language, you got a problem. And you might be left holding the bag.
So that absolutely, they might not know it because nobody tells them.
And this is complicated nuance. So if you don't follow it, don't feel bad. Feel free to call any of us at any time, and I'm happy to explain it, especially if you're going through it.
So the objective is to maximize the benefit to the client
Yes.
regardless of where that benefit comes from, right?
Absolutely. Yep. At the end of the, that's it. By the way, I would say this too. Who we represent, public safety, fire, police, probation, parole, whatever your position is.
Corrections.
Corrections,
Nursing.
everybody. You know what? They have locker room environments. So if you're protecting them, it's a culture thing, by the way, for me anyway. If you're helping them out and you help them in a good way, and they're realizing you're educating them, because guess what, people, this is very complicated. And if you're helping them understand it, then guess what? In the locker room, they're saying good things and things like that. And they know, I always tell them that's almost like a little insurance policy. Because of who we represent, we're not going to be trying to do a quick deal and get out of the case. We're here in a long-term environment with long-term relationships and things like that. And that's what's best for a client, without a doubt.
Organic and authenticity matters.
There you go.
Right? And so this is going back to what we said earlier. Our number one job is to protect you, right? And in doing so, that we got to check our egos at the door.
One thing I want to talk about is I want to go back to PTSD claims and some of the hidden dangers of that. And I want to have Dawn talk about that in a little more detail. And then Victoria, I want to have you address that as if the officer in our scenario or the employee has a PTSD claim, how is the employer likely to use that in the civil cases that are pending or the disciplinary action that they're prosecuting against officers? So first, Dawn, let's go back to PTSD, because I find this fascinating. I know it's very, very, very prevalent. In our scenario, we have an injured officer who has a lot of orthopedic injuries from the accident, but also has a serious PTSD claim. And my understanding is that those are not the kind of things that resolve overnight. And he may
Or if ever.
Ouch. And he may need various forms of therapy and treatment for years to come. So how do you deal with those? What are some of the complications or hidden dangers of PTSD claims?
Look, everybody's different, right? No two cases, no two people are ever the same, right? Everybody has a different walk of life, a different backstory, different work environment. And so you have to treat each one differently, and you have to be open-minded, right? And so getting back to the protection aspect, what is their goal? Because that's how I drive the case, right? So if their goal is to get proper help, get back to work, that's how we're driving the bus. If their goal is, I can't do this anymore, I'm afraid I might cause myself harm or jeopardize one of my coworkers in the line of duty, then I drive the bus that route. Typically, the expedient route is go to EAP, talk.
What does that mean, EAP?
Employee Assistance Program,
Okay.
right? So a lot of unions, a lot of public entities will have a certain preset amount of EAP sessions where you can go get counseling. It's a little bit off the grid or more off the radar.
Mm-hmm.
But ultimately, my main goal is for them to get expedient help and care, right? And so a lot of times that's private insurance, EAP. Depending upon how strong their POA or DSA or fire local union are, I usually say try to engage them to see if they can help advocate for you with the employer to maybe get you to the West Coast post-trauma retreat. There are plenty of retreats out there that specialize in helping first responders. And it's a good 5 or 7 days where you're there with round-the-clock, clinical professionals in all aspects, individuals who have walked that line, whether it be fire or police or what have you. And it's a collaborative approach. The most difficult cases really stem with the ones that are in denial. One of my jobs with these individuals is to help them be vulnerable. That stigma, it takes more of a man or woman or adult to address the problems you have than to bury it, right? It's easy to hide behind it. So I turn into a counselor in a lot of cases, and I applaud them and reassure them they're doing the right thing and tell them I'm proud of them, because it could be life or death. It could be eating a gun or a bullet, right? And unfortunately, I've dealt with the back end of those cases. And so anything I can do to mitigate and prevent and help, I'm going to do it. I mean, I help get decon units in the fire stations in my local town to help mitigate cancer. Now, that's not in my economic best interest, right? But anything I can do to help public safety have an enjoyable retirement instead of an early funeral, I'm going to do that. So my primary goal is to get them immediate attention and reaffirm that they're not alone and that people care about them and that they're not doing something wrong. And it's not a sign of weakness. It's a sign of strength.
Yeah, that's great advice. I'm just thinking about that. In all the years you've been working in this highly specialized area, have you seen an increase in psychological related claims or PTSD claims, or have you seen an increase in people willing to talk about their mental health situation and bring claims?
Absolutely. And I think if it's a lot of multifactorial,
Yeah.
right? So it comes from different avenues. I've seen it come from more tenured employees, 25, 30 years, and they got to the point they're like, I've dedicated and sacrificed so much. Screw it, I'm pursuing this.
Yeah.
And they start imparting that knowledge and education on their younger peers, right? Hey, it's okay to not be okay, right? That saying, go get help. Even if you don't have a problem, go talk to someone. Don't bottle it up because you don't want to bother your spouse at home with it, right? And so I've seen it from that angle. I've also seen it just from internal affairs investigations where they get to the point to where they finally feel that the department no longer has their back, right? And they feel like they're left on an island, so they're finally getting the help they need or they want. And I've also I think there is a lot more understanding and openness to discuss it now to where it doesn't feel like a disease.
So the hypothetical we've talked about is our officer, besides being criminally prosecuted, was being terminated and has a PTSD claim, which the employer promptly on the workers' comp side said, your stress-related, psychological-related symptoms are not due to the accident or not due to your years of service before that, but are because you're stressed out because of this personnel action.
Dawn, isn't there a presumption for the 4850 claims that if the PTSD occurs while the officer, I guess, is on duty, it's...
So PTSD is a
be from that?
presumptive injury now.
Okay.
Okay. And that's fairly recent, in the last 5 years or so. And so ultimately it is presumed work related, but so is a duty belt, low back presumption for peace officers. So is heart trouble.
Cancer.
It doesn't mean cancer. Cancer is a whole nother tricky one with latency period, et cetera. But it doesn't mean they're going to pick it up. Right. And so we have the burden of establishing that. So PTSD, there's a lot of people think, oh, my psychologist or my LMFT said I have PTSD. That's not a formal diagnosis. You actually have to go through the full-blown evaluation, go through all the access, and actually get diagnosed with PTSD.
Through the
Right.
QME, or can it be through your
It could be
PCP
through-
as
It
well?
could be through a licensed professional,
Okay.
right? That doesn't mean they're going to honor it. They might still trigger the QME and say we disagree with it, and they have a right to discovery. I usually try to be aggressive, and if the defense is dragging their feet, we'll file for what's called a priority conference, which will set up like an expedited trial on just causation, right? And that'll force them to either get off their butt and conduct discovery, or we go to trial, right? And I usually don't do that without the proper evidentiary support I need.
Of course.
So yeah, it is presumptive, which means it is presumed work related if you do in fact have that formal diagnosis and it manifests itself while you're employed, right?
When you say it's presumptive, that means that it's presumed to be job related and the employer has the duty to prove that it's not? Is that what
It's
that's?
a rebuttable presumption.
Okay,
Right?
rebuttable.
They're all rebuttable. So they can rebut it. They could come up and say, well, you have these, psychological records from, 1998 when you were 14 and you were molested by your Uncle Vito. Sorry if someone's out there, Vito. It's just the first
No
thing that
offense,
popped in my
Vito.
head. So they could try to rebut it, right? And go through that avenue. It's very difficult to rebut it absent something crazy in the file. Now, getting into the good faith personnel defense.
Yeah.
So if the good faith personnel defense is raised, and essentially what that's saying is, look, a large part of these symptoms and problems under the PTSD umbrella are a result of a good faith personnel action, i.e. An investigation for some alleged misconduct or wrongdoing. Now, in those scenarios, the QME or AME is charged with doing what's called a ROLDA analysis. And ROLDA is a case. It's ROLDA. And what that says is, let's say hypothetically, the doctor says 75% of your symptoms are work-related, 25% are non-industrial pre-existing because of Vito, right? Whatever it might be, right? So that 75% is now going to be dissected and broken down based upon causative factors. The 3-month-old that died in your arms given CPR, the brutal scene that you respond to on an accident, the domestic violence call that you walked in to step on someone's brain matter after they shot themselves with a shotgun. These are real scenarios, okay? And so that doctor is going to be charged with now taking that 75% work-related and breaking it down to make sure more than half, right, that the majority is not associated with good faith personnel. Now,
And is that the threshold you that's critical? Is that 50% threshold?
Well, yeah. So you need more than 50%.
Okay.
I don't want to get too much into the weeds. It's going to
Okay.
get confusing. So the ultimate factor is if they're asserting good faith personnel, the doctor needs to break down what percentage of your symptoms are related to personnel actions
Gotcha.
versus the regular course of work exposure. Then you go to trial on whether those personnel actions are considered good faith or bad faith. So the judge, ultimately the trier of fact, the judge is going to determine what personnel actions, if any, are considered good faith or bad faith, right? And so we have these he said, she said moments between, an officer and a sergeant, or a sergeant and a lieutenant, or what have you, and whether or not there is some, because you referenced locker room, culture earlier. Look, and there are personality conflicts, just like any other career, any other industry, right? And so you're going to have Officer X have a problem with Lieutenant Y. And Lieutenant Y might be railroading Officer X, right? So we need to determine whether or not that railroad job is good faith or not, right? And a lot of that's subjectivity on the part of the judge and how we convey that and articulate that.
So, okay, so naturally then, Victoria,
Yeah.
from the employer's perspective, so now we have, the employers prosecuting a disciplinary case against the employee. The employees filed a workers' compensation claim for all their injuries, but also got a psych claim, PTSD claim. How does that affect your analysis in advising the employer, and what can they do with that information, and can they use it to their benefit, to the detriment of the officer? What are the implications?
I think that's fairly complicated too. So I think the first thing I would tell the employer
Well,
is,
let's be clear. This whole mess is super complicated.
I know that's true. That's a good point. Is to refer your employee to the EAP program, like Donna mentioned, because you usually get between 12 and 15 different therapy type sessions. After that, the employer doesn't have a duty to provide additional, income or bonus or whatever for that specific employee to get therapy. But I would have them probably encourage it to them anyways. But the employer then steps in to be able to accommodate that employee. So say that they are diagnosed with PTSD and they want to take some sort of leave, whether through FMLA or CFRA, you can also take intermittent leave. So you don't have to be off for, 12 weeks. You can
And let me just stop you.
Yeah.
FMLA and CFR, what are those acronyms?
It is, CFRA is the California Family Rights Act.
Okay.
And FMLA is the Family Medical Leave Act.
Yeah, FMLA.
Yeah, and that's the federal counterpart of CFRA. So they have different requirements too. So in order to get FMLA, the employer has to have at least 50 employees within a 75-mile radius.
Gotcha.
For CFRA, the employer only has to have 5 employees. So it's a lot more expensive, right? Because then it could still take the 12 weeks.
And generally, what does it, before, I don't want to digress too far.
Sure.
But what do those leave programs provide, just employees' ability to take time off of work?
It gives you 12 weeks off, and it's job protected. And you can take it for various different reasons. So federal is more restrictive because it's more your immediate family. In CFRA, it could involve a grandparent. If your grandparent gets sick, so you can take off 12 weeks to help them.
Okay.
But the intermittent part that I'm talking about is important because if you need to go to a therapy session on Tuesday for 2 hours, then that'll just take away from the 12 weeks that you get, instead of saying, I'm going to be off for this 12 weeks and do intensive therapy.
It's done on an hour.
Yeah, it's just like pieces of it. So you can have
2 hours considered 2 hours, or does that count as a day?
I mean,
do they apply that rigorous?
I guess it would. I'm not 100% sure. I would say that it counts as a 2 hours if the employee is paid hourly, and if they're not, then it might be different. But either way, I know when I took leave when I was pregnant, I was able to calculate it myself and be like, I get these amount of days, and they agreed with me. So so it really.
Okay, so following up even further, you have this employee who's filed a PTSD claim. As the employer, does the employer now view that employee? And let's assume this employee is not going to retire. This employee will come back to work, hopefully, or wants to come back to work. But from the employer's perspective, do you now view this employee as a potential source of liability or a greater risk because they have filed claims related to their mental health condition, especially with an employee classification, a public safety employee, especially a police officer who's carrying around a weapon?
Unfortunately, yes. We would all hope not, but yes, there's more liability
Well, that's all. Don, have you seen that? Have you seen that with the
I have.
employees?
Yeah, not in their environments, but in a civil matter, I have. And that drives a plaintiff, an officer, to be very, very cautious, very, very sensitive. And they say, hey, I don't want this to get out. I don't want this to go that way because they're going to take that my ability to qualify every year. Then that's my job.
Qualify the gun range.
Qualify the gun range.
Have you seen that,
They'll
Dawn?
do like a fitness for duty exam too, right?
Yep.
So
it's for exactly.
Ultimately, this comes down to that initial intake, right, or consult where I go to protect them. What is their goal? And if they are apprehensive that they don't want to go through the past or risk losing their ability to carry a firearm, I'll strongly suggest that they go get EAP or private treatment. In that same vein, I'm also kind of interviewing them to personally identify whether or not they're a harm to themselves or others, potentially, right? Because we do have a heightened obligation and there's a reportable, component. So, it gets back to protecting them. And in some instances, it's not just from their job or an economic scenario, it's protect them from themselves.
Yeah, very much. I applaud that, by the way, because it's, I've had officers that they get frightened. They don't know who to go to, and this is what I typically say. I'm just thinking of a certain officer who is exactly in this environment, and I told this particular officer, hey, if we sprain our ankles, go to the doctor and get a brace for your sprained ankle. But if you spray your soul, you spray your psyche in some place, or been trained to almost stigmatize the whole thing, and don't do it because then you'll lose your job. This will happen, that'll happen, your marriage will fall apart or something. And, I always try to encourage them, like you, Dawn, hey, it's okay to get help. It's absolutely okay. In my world, by the way, I do simplify it a little bit. I say, okay, PTSD and any kind of psych claims that go on, psychological claims that go on in comp and anything like that, I like to not hide them, but I like to keep them out of the litigation unless absolutely necessary. And if they become necessary in the terms of what we call general damages, emotional distress damages, that becomes, a lot of times you see these big verdicts and things like that, big recoveries, it's because of that component. I do protective orders on files. So personnel files and things like that, very common to do. There's a thing called a pitches motion. If the other side wants to get the officer's personnel file, which oftentimes includes psych records or PTS treatment, things like that, I say, okay, because ultimately the judge says they got to do it. In other words, you got to turn it over, Peacock. They have to be able to see it. Then what you do is, so how do you address that? I address it by doing, I don't know that that's necessarily available to you, but I address it by doing a protective order. And that's like, hey, if you release these records in any way, you being the insurance company, there's going to be some problems. There's going to be additional damages and things like that. And those are always granted. That's my experience.
So the problem with workers' comp is if they bring a PTSD claim, they brought the issue up.
Yeah.
And so the pitches motion.
I mean, they being the employee.
The employer. The employee. And so, usually how I get them to really look at filing a cumulative trauma claim at the end of their career or a PTSD claim is you have to really bring them back to how they got here. How many sacrifices have you made throughout your career? How many birthdays have you missed? Anniversaries, Christmases, Thanksgivings, recitals, right? And that usually kind of humanizes it for them. Yeah. Like, you know what? Yeah, I do deserve this because they are benefits that they are legally entitled to, right? And they have this stigma with I'm suing my employer or, I don't want to be that guy that gets these benefits. Like, no, you are that guy. You are that girl that deserve them.
So Victoria, though, back to you. So the employer views the employee now that's filed a PTSD claim as a greater risk, maybe a greater liability, but doesn't the law protect that employee from discrimination because of his or her medical condition, including mental health condition?
It does via the Fair Employment and Housing Act.
Yeah.
So the thing there to consider, though, is that employees are terminated all the time, even though they're in protected classes.
Of course.
And protected classes include, over 40, gender, sex, religion, those types of things. Just because you do have the disability, the mental health disability of PTSD, doesn't mean you're shielded from being terminated if the employer has a legitimate business reason to terminate you. So in this case, say his PTSD was really affecting him and he was now a danger to, the community, then he technically could be terminated without, and his lawsuit wouldn't be successful because they would have a legit business reason to get, to terminate him. And that's why they would do the fitness for duty exam to see, can he hold the firearm? Can he do this? We actually had a case like that. It was a sheriff's deputy, and the same thing happened. He had PTSD. They did a fitness for duty. We filed a discrimination and other lawsuit related to disability. So when you have a disability, the employer also has to engage in the interactive process. So say how you had your shoulder surgery. If I was your employer, even though you're my boss, and I saw you with that, then I
We're
would
co-workers.
then I would ask you. I mean, it's obvious that you have some sort of surgery. So I'd come up to you and say, hey, do you need any sort of accommodation? Do you need a new keyboard? Do you need something for your arm? Because employers are supposed to be proactive in trying to figure out what can we do for this employee. And you even have to go further by saying, okay, if you can't do your current job, is there another job you can do or some other thing that we can offer you to do?
Okay, so this is not just for your standard shoulder surgery, knee injury. That could be for mental health claims, PTSD claims.
Yeah, so disability would be mental or physical.
Of course, that's going to have an interplay with Dawn's workers' compensation claim.
Definitely.
Have you seen a scenario to where they're calling for a fit for duty, but because they filed the workers' compensation claim, their treating therapist won't allow them to? Is that a protection? Can that stay that process, if you will?
Can the treating therapist prevent them from doing the fitness
Well,
for duty?
let's say it's a PTSD claim.
Okay.
Right? And they are potential harm to themselves or others at that time.
Right.
Right. They're not permanent and stationary. So that means there's room for significant improvement.
Okay.
Right. That therapist says, no, they cannot engage in anything that's potentially work related because it might be a trigger to set them back based upon the progress they're making.
I see what you're saying.
Could you potentially use that as a shield?
I don't think the therapist would be able to stop that from going forward.
What about testimony?
Potentially testimony as a shield, yeah.
Without killing an hour talking about fitness for duty exams, my biggest advice on fitness for duty exams is you need to talk to Dawn, Mark, Victoria, me, maybe all of us before you go to your fitness for duty exam. Your employer will order especially a psych-related fitness for duty examination, and sometimes that is a biggest setup in the world, and it depends on who your evaluator is. So, Dawn, you probably know
I've
evaluators out there.
Well, yeah, and I've had a client. The reason why I asked that is I've had a client where the city backed off until he got to a point to where he was allowed to, right? And now, and
That's
that could be
interesting.
any particular employer, right? So just because one city does X doesn't mean this county's not going to do it,
Yeah.
right? And so it depends on HR, different management levels, but they actually backed off and let the process unfold. And he still hasn't had it. And it's been like a year and a half.
Well, if they backed off, it seems like they probably wanted him to come back. So you do have the scenarios where they don't want him back. They didn't. Wow, and they let it go through anyways. That's really
Because I've
interesting.
seen employers abuse that process so much.
Yeah,
They have an
I too.
employee they want to get rid of, and they tee it up on a
That's a very large public entity.
Wow.
the
So-
fits is in on the fitness for duty exam, and sure enough, the evaluator comes back that the officer's unfit for duty, and the employer, sanctimonious as ours, said, we'd love to take this guy back, but he didn't pass the fitness for duty evaluation.
That happens. That's a good point too.
But he's temporarily disabled, right? And so that, I mean,
Well, if he's temporarily disabled, he's probably not working in the law office unless he has a reasonable or not law office. Sorry,
no, you're good.
unless there's a reasonable accommodation of him, right? That I'm temporarily disabled, but I could still do X, Y, Z, like filing or whatever it may be, and then he
Right,
come
so-
back.
I guess where it gets tricky on these is if they are actively treating and there is some improvement and they're not permanent and stationary, they still have the ability, if the therapist or treating professional says so, to get to the point to where they might be able to get back to work full duty. It's a really slippery slope,
Mm-hmm.
right? And how does the employer push for a fitness for duty when it's premature, for want of a better phrase? Does that make sense?
I get what you're saying, yeah, but
But it's
they
business
haven't
necessity.
gone through their full therapy. So how can they realistically be fit if they haven't got what they needed?
Right.
Before we leave today, I want to get kind of some takeaway thoughts and comments from each of the fine lawyers that are with me here. And I'll start with Victoria. Based on what we've talked about and bearing in mind the hypothetical that we've used kind of as a foundation for our talking points.
Yeah, key takeaways for employers would include preserving evidence. So there is a spoliation letter, which means, you're under the duty to keep everything related to text messages, emails, body camera footage. You really need to keep documentation of everything because that will help protect you and your employee. As far as what employees should consider, again, actually documentation. So the more documentation you have where you notify your supervisor or manager that you have PTSD, and if they do nothing to then, provide you an accommodation or engage in the interactive process, then you might have a civil lawsuit there.
Mark, how about you? Key takeaways.
I'd say, there's many in my head, but I'd say the two primary ones. Number one, be aggressive, be assertive for yourself. Contact an attorney who knows public safety. As you can tell from the conversation here, there's so many nuances to all of this, and there's so many aspects of interplay. It can get overwhelming and intimidating. I would still say, hey, call a union president or somebody. Get in touch with an attorney who knows this business. That's very important. And number two, if you have an environment that involves, crossovers, make sure that all the attorneys also have that same type of experience and expertise. And a practical takeaway is take a look at your personal insurance policy. I've been beating this drum forever and a day. Get as high of level of uninsured and underinsured coverage as you possibly can, and then bump it up with an umbrella policy. Okay, that's you paying you. That's the insurance company paying you, taking care of you, not necessarily taking care of the other person who very well may have caused the accident.
That's huge. And then, Don, how about you? What are some of the takeaway thoughts you have that based on our conversation here this morning?
Educate yourself, right? It costs you $0 to call and have an appointment with me to go over your scenario. And I'm not that good at math, but that shouldn't hit your pocketbook too hard. So educate yourself. If you're on the fence about filing a claim, call an attorney that understands your line of work, like Mark said. If you don't trust that attorney, don't hire them. It's really important that you trust the person you're speaking with and that they actually genuinely care and understand you. I may not always understand you, but I sure as hell am going to try. Know your presumptions. That goes in line with educating yourself. You have a myriad of presumptions available to you based upon, whether you're a police officer, firefighter, correctional officer, state parks employee, meningitis, heart trouble, hernia, pneumonia, cancer, low back duty belt, PTSD, tuberculosis, Lyme disease. I mean, there are a plethora of a lot of presumptions that extend to you that you may or may not qualify for. So if something feels off, if you feel uncomfortable with the scenario, you want to run it by someone, give me a call. Give Mark a call. Give Paul a call. Give Victoria a call.
Beautiful. Love that.
So look,
Thanks.
just take the time. I mean, you sacrifice so much. You put everything on the line for us. And I have ultimate gratitude for the sacrifices each and every one of you make. So make sure you know who you're talking to. Make sure they know what they're talking about. If you don't feel comfortable, keep interviewing attorneys until you find one that fits. I think it's really important that you have that trust factor.
One of my key takeaways is I think it's obvious that the interplay between these different legal areas, there's so much overlap. So regardless of what you do, you need lawyers who communicate and are not out there on an island just trying to drive up their fee. We appreciate your time. Please hit the subscribe button. And again, thanks for joining us on Dissecting the Legal Issues, where we protect those who protect us.